Hi everyone, in this week's dispatch we are continuing the redundancy and restructure theme, and we're starting an exciting four-part bonanza on suitable alternative employment. According to Google, it's also called a quadrilogy, so strap yourselves in for part one, which is a general overview. Now, the Employment Rights Act doesn't specifically require an employer to look for suitable alternative roles. It is, however, subject to the general test of reasonableness, and a failure to do so is likely to render a dismissal unfair. The Act does deal with the consequences of an employee being offered and potentially accepting suitable alternative employment. Firstly, if they do accept, the employee's existing contract will not come to an end, even if that employment is offered with the employer or an associated employer, and we will come on to group companies shortly. That does mean that continuity of employment is preserved in those circumstances. Where the employee unreasonably rejects an offer of suitable alternative employment, they will forfeit their right to a redundancy payment, and a later video will focus on what is reasonable or unreasonable in those circumstances. And suitable alternative employment is subject to a trial period if the terms of the new employment differ in any respect from the employee's existing terms. That gives both parties essentially the opportunity to try out the position and determine whether it is right for them. The Quinton Hazel case confirms that the duty is not to make every possible effort to look for alternative employment, but to make reasonable efforts. And what we'll stress throughout this is that the paper trail is very important. So we do have to provide evidence in an unfair dismissal case that we have undertaken a reasonable search, and that may mean documenting when we've provided those roles to employees, maybe notes of consultation meetings, the provision of job bulletins, that sort of thing. So we talked about the possibility of alternative work with an associated employer. In Barrett Construction, it was stated that there was no obligation to expect an employer to look within all independent group companies for alternative roles, but we do contrast that with the Eurogard case, where an employee was made redundant from a particular entity, and they had considerable influence over the parent company who did have vacancies within that business. In those circumstances, the tribunal did expect that the company should have exerted influence over the parent and provided an opportunity for suitable alternative employment. So it's the degree of control which is important in those cases, and we must be aware that the obligation to look within different group companies may well apply depending on that degree of control. Contrary to a number of employees' misconceptions in these cases, the employer is not obliged to create alternative employment where it doesn't exist. So we don't have to go and provide something over establishment to meet the employee's skill set, no matter how long they've been employed or no matter what their skills are. We have to undertake a thorough search though, and again, evidence the steps that we've taken should it become necessary to produce that evidence in an unfair dismissal claim. And it's also important to note that that duty applies right up to the last day of employment. So we may serve notice of termination on an employee and have no alternative roles for them at that point. They may leave 3 months later having worked their notice, and the duty to consider alternative roles does continue right up until that last day. Now we also have to provide sufficient information about any vacancies so that the employee can take an informed view on whether they wish to accept or not. It's not enough to simply say there is that role there. We should be giving information about any potential changes such as salary, status, benefits, working hours, so that they can decide whether or not that's for them and they want to apply. So that was a whistle-stop overview of suitable alternative employment. What we'll move on to is how we actually make that offer to employees and how we may decide between a pool of employees where we have a limited number of vacancies available. In the meantime, if you do need to get in touch on any employment law matter, please do email employmenthub@chadlaw.co.uk. Thank you.